A couple questions that I'll ask these gentlemen, and thankfully they have answered a few of them already. Has, in the creation of other stewardship districts, have there been voter referendums with regard to the creation of the stewardship district?
The short answer is no. There are typically a landowner referendum after the act passes to have the landowners come back together and say, yes, we asked the legislature for it, yes, we confirm we want it, but no. I'm unaware of any referendums that may have been held in broader geographic areas like a county at large or a city at large on other prior stewardship districts.
Is Rayonier opposed to a voter referendum with regard to this, given the fact that this is 24,000 acres and a large percentage of the property that lies within Nassau County?
Well, I think we're comfortable that the existing legal process, including consideration here and all the stops that it takes, provide sufficient public input. So we're not asking anyone to expand the legal requirements for creating a district beyond what the state law requires.
So would Rayonier be opposed to a voter referendum?
It's not a question I've discussed with my client, but my instinct is that we would prefer to stay with the customary state law process. We don't think it's necessary. We think we're providing adequate public input into this process.
And with regard to the governance of the stewardship district, what is this body here ceding to the governing body, to the landowner Rayonier? What powers and authority and determinations are being transferred from them to Rayonier?
Not a one. Everything that this commission would do for the development and relating to the development of lands within the ENCPA, you will continue to do. They will continue to do. What we're doing is creating what we think is the most effective and efficient mechanism for the community itself to provide for the improvements, to fulfill the obligations to the county, and to govern itself. So we're giving the lands within the ENCPA what we think is the best tool for development, but we are not taking a single thing away from Nassau County.
Well, I don't understand. What is the benefit of giving them that tool, of having that body? And what is it adding to you all? And if it's not subtracting these folks, that's great.
It's adding to the ENCPA and the landowner and its future residents, and we think it's adding to the county in several respects, some of which we discussed in the slides. It's putting in place a bondable, bankable entity to ensure not only that the upfront obligations on this property are met, but to ensure that there is an entity in the long term who will continue to be available to maintain those improvements and provide those services. Districts across the state have been proven over the last 20 years to be, they're the preferred permitting entity for water management districts. They are more hurricane resilient. They are able to participate in the mutual aid program with the Department of Economic Opportunity. They are more bankable given their access to the tax-exempt bond market, whether it's through the traditional bond process or even through the process of bank loans on a tax-exempt basis. So it's giving not only this community, your future neighbors, our customers, and your future citizens an entity that will ensure that all of those things happen. It's also giving this county one point of contact that will be here in the long haul to continue to fulfill those obligations, to continue to abide by the terms of the interlocal agreements we'll expect to be discussing in future years as we coordinate on the mobility transportation program, et cetera. So we think it's adding to us, and we think it's adding to this county, frankly.
What happens if this project goes belly up, or if Rayonier's corporate leadership decides that this is not something they want to follow through with in the future? To the residents who buy in, let's say in the next couple of years, what happens to them?
Nothing worse, and in fact something better than if those residents bought into a community without a district. For all of us who lived through the real estate crash of 2008 to 2013 approximately, we had a number of real estate projects around the country and around the state of Florida that suffered in malaise. We had foreclosures, we had loan defaults. With a district in place, the money is raised up front. It's held by an independent trustee. This is all provided for in the law. To the extent that Rayonier were to walk away from the project, it provides a tool, which is a district, and an asset, the money that's held in trusts, to provide for a workout and to provide a subsequent buyer. So if you looked around the experience in the late 2000s and early part of 2012 and 13, real estate projects that suffered a default or that suffered a change in developers recovered faster on average than projects which only had a homeowners association. Again, it's a tool and it provides assets. It provides comfort for you to know that that's out there, that those monies that are raised with bond funds to build the improvements within the community, if somebody walks away, the unexpended proceeds are still there. It provides an asset also in terms of those bonds. And what you saw from that time period for districts that had real estate projects that suffered, somebody was able to come in and buy those bonds. And it was a blue light special at Kmart. Somebody bought them for 40 cents on the dollar, came in with that investment, was able to turn the project around much quicker than those projects that languished on the balance sheets of your traditional banks. And we think that's a win-win.
So the bonds will be sold prior to any dirt being turned over?
The timing of the bond sale, it can occur before, it can occur during, it can occur after. And those are decisions that we don't think we've made yet, but typically, if we're gonna build a road, we will begin by starting the bond process, imposing the assessments on the land, going to the capital markets, getting that money, and it's held to build the project.
So it's not quite true that that exists for security of residents of the ENCPA up front, because you might raise those funds as you go along.
Well, I think that's an oversimplification. I think it's absolutely true. If we're building a $10 million road, the capital markets, and when I say that, the typical buyers of these bonds are, State Farm Insurance, the Franklin Fund, Nuveen, Invesco, those kinds of large investment houses. They're not going to loan us the money for half a road. At the end of the day, we have to be able to show them what our plans are, how much it's going to cost. The project generally has to be built within the next 3 years under federal arbitrage rules. So no, we do think it is an absolute protection.
Okay, but all the bonds are not going to be sold up front.
Well, by way of example, to build out Lakewood Ranch, the estimated bond budget, if every improvement that was capable of being funded by bonds would have, it exceeded 7 figures. Well, actually, it was well over $1 billion. If you did that, nobody's going to raise that money up front. But you would say, well, what's the first tranche? What's the first piece? Is it wildlife, whatever it may be? What are the roads? What are the stormwater systems? That money is raised up front as we begin construction for the improvements that the district's going to fund. The district doesn't exist yet, so we don't have a district to make those decisions yet, but obviously that's why we're here today.
Mr. White, if you could, I know we're letting you go, but I'll give you another 3 minutes, and if you guys have other questions after this, you can submit them, and I'm sure we'll have them 28.
Okay, great. Wonderful. Let me ask you about the St. John's Water Management District. Are you all still going to be under their purview?
Absolutely.
Okay, and the Department of Environmental Protection as well?
Absolutely.
Okay, great. There's a clause that bothered me as a lawyer a little bit, that with regard to the landholder seeking to obtain sovereign immunity. Could you explain the importance of that and why Rayonier should not be required to secure insurance or some other kind of risk liability rather than impose that upon the public? For sovereign immunity?
Absolutely, and I'll say I don't think that we impose sovereign immunity on the public. Every district in the state of Florida, including the 6 CDDs you have within your county, and all other kinds of districts in the state, are defined by general law as political subdivisions. They all share in the state sovereign immunity, which means that our liability in tort is capped at certain thresholds, and those thresholds are set for general law. We're not asking for anything different for the lands within the ENCPA. Sovereign immunity is important as we undertake all of these infrastructure obligations. As you can imagine, that limitation on tort liability for us is the same as for you. It would be no different. And at the end of the day, it doesn't abrogate the need for insurance. You will see on the projects, because it will be public record, assuming your approval on the 28th and the legislature's action. When we award a construction contract, it's all going to be in the public record. There will be insurance that the contractor will provide. The district will have real property and casualty insurance. The district will have directors and officers liability insurance. As the district takes on property, it will have coverage for that property as well. So just like you, I suspect, have insurance that backstops your sovereign immunity, the district would as well. But I would dispute the characterization that it's an imposition on the public. I think the reason that districts around the state have it is the same reason that you do. The important functions that we provide and the important infrastructure work and other services that are done really argue for that, for the benefit of the public, not for the detriment. And in fact, I will say that's why a district is, in my view, a much preferred mechanism for community governance over a homeowners association. We've all read newspaper horror stories about unfortunate incident at a pool, for example, and seeing the insurance rates skyrocket, which makes everybody's homeowner association assessments go up, districts with sovereign immunity protect the residents of the ENCPA from that kind of scenario, which is why I think it's a much preferred mechanism.
Well,
Okay, one last question, Mr. White.
all right, there's a provision in the proposed legislation which calls for that the legislature should not interfere with the bond, let's see, pledged by the state to not interfere with the bondholders of the district. Can you tell me what that means?
That is implementing the provision of the Florida Constitution, which prohibits the impairment of contracts, and that is also standard language that you will see in Chapter 190 governing community development districts, as well as the legislation by which other stewardship districts have been adopted and created. It's an important thing, and the reason it's in your Florida Constitution is that it would be a difficult pill to swallow for an investor to come in and say, I'm going to loan you $20 million to go build this road, and worry that the state of Florida, through the legislature, may come in and dissolve that contract. But it is simply implementing the provisions of the Florida Constitution.
Okay, and just as a forewarning, on the 28th, I will ask you about how your lobbying activities have progressed, and to the extent that you all have made, or some affiliated entity have made campaign contributions to our legislature or anybody else, I'll ask you for that information. But thank you very much.
Thank you.
Thank you, Mr. White.